Hey, I'm Chad Brown. Welcome to Disability Expert Podcast, where we talk about all things disability. And today is no different. We have with us today Aaron Dalton. And so, Aaron, thanks for being with us.
Thanks for having me.
Yeah, I'm so excited. Aaron actually works with us here at Chad Brown Law. He is the practice group leader for our federal court appellate practice, as well as our private long-term disability practice. And today we're going to hit a topic that's, golly, it's just sort of tough to talk about, but is a reality, is that we don't win every case. No attorney wins every case. No one represents themselves wins every case. The reality is sometimes you go through this long process, a couple of years, and at the end of the day, the judge says you're not disabled. And while that's crushing, the question becomes, what do you do next? And the answer to that is you should be figuring out whether you should appeal your case ultimately to federal court. That's where the decision-making probably should be made. And that's what we're going to talk about today, because that's what Aaron does here for us, both for all of our clients. And then we have a bunch of attorneys who send cases to us on a regular basis to help figure out how to help their clients when they unfortunately lose hearings. So just sort of walk people through, because this is not what people realize. They don't think about that being a disability lawyer. They think much more about, the person who does their pre-hearing and engages them and does the hearing. So what are you doing as a federal disability lawyer? Like, what do you actually do?
Yeah, so you mentioned this is the hard side of the practice, but I do like to be able to come in and give the good news of your case is not dead yet. Just because the judge did not agree with you on the first round does not mean that you have to give up. And so I do get to break some good news sometimes where I say, we're not done fighting for you yet. Here's the issues we can appeal on. But to get to that conversation, I have to actually sit down with the judge's unfavorable decision. And really what I'm looking for is first level, just within the four corners of the document, are there errors that we can appeal on? And then more broadly, did the judge explain the basis for the decision, or are there things, maybe because I was the hearing level representative and I know, hey, there's stuff in the file that the judge just did not account for in this decision.
Right. So at one level, when you're a hearing level attorney, you get to dive into the medical, you dive into the vocational. So you have to sort of think like a doctor and then think like a vocational expert and sort of mash those together and apply the law to figure out, hey, do they meet a listing, or are they able to maybe win their case under the grid rules, or is there just an argument they can't do any work? But at the appellate level, it's much more about true legal analysis. So one of the ways I like to help explain to people is when we look at your case at the hearing level, what we're trying to do is figure out what's going on with you. What's going on with you that kept you from being able to do the jobs you used to do and any other work? And then how can I take those sets of facts and apply them to the law to be able to convince a judge that you're disabled? And I think what people should understand in the federal side is I want to talk about client's response to unfavorables here in just a minute, but they need to understand this is a much more academic type exercise, which one of the reasons I think you've been so good at it is you're so strong intellectually and such a strong academic, is it's very much an academic exercise where you're looking at that decision saying, okay, the law said you had to do X. Did you actually do X? Did you follow the law? Did you follow the rules? You think that's pretty fair interpretation of what you're doing?
Yeah, absolutely. And the Fourth Circuit has some sort of anecdotes that they use to make this a little bit more relatable, where the case law says, did the judge build an accurate and logical bridge from the evidence to the judge's conclusions? And so a big part of what we're doing in federal court is reading that decision and saying, can I walk across that bridge from the evidence in the record that we were using at the hearing level to the judge's decisions in that order?
Yeah, it was so funny. I was thinking, about some of the prior episodes that we did, and I was thinking back to Eric Goodell's episode. I think Eric was like our first guest on the podcast, and you do, and we work with Eric's firm and do his federal court work. And Eric was like, I remember in our podcast, he was talking about how, he really liked sort of the street lawyer side of it. Like he liked doing hearing work because he felt like, hey, I get to go in there and make common sense arguments and really just sort of look at it like, how practically can I change someone's life? And sort of the other side of that is when he's not able to practically win their case, then it comes back and it's more true legal work and legal analysis. So that's what you're doing. but you don't do it in a vacuum. That is, we don't just look at decisions and sit in the corner office and never talk to client. What are sort of like the client reactions and things that you're dealing with when the client loses the case? Because a lot of times they've read the decision. So what does that look like typically from the client side?
So there's a couple of responses, and a lot of them deal with the timelines, which are just absolutely brutal because the client at this point might have been waiting for 2 to 3, maybe even 4 years to get this decision in from the judge. And
Right.
so a lot of times the reaction is either, well, I've put this much time into it. You're telling me you can take it to federal court. Great. What's another 1 or 2 years?
Right.
And then the flip side is, oh my goodness, it's going to be another 1 or 2 years, and I've already waited this long.
Yeah.
And so kind of trying to walk clients through, the reasons not to give up on their case at this stage.
Right.
And trying to help them deal with the emotions of that, because, I think a lot of clients, it really hurts when you've spent 45 minutes testifying to this person in a position of power about all the problems that you face, and they just say, well, no, I don't believe you.
Yeah. I mean, I think one of the reasons, I can't remember who was on, I can't remember which podcast, I can't remember which guests we were on there. We got in this conversation about dabblers, which are lawyers who sort of dabble in disability. And one of the reasons that, not that any lawyer who does a case couldn't do a good job, but I think one of the big problems with dabblers is I don't think a lot of times they fully understand the import of how this case is impacting the client's life. I mean, very many times I've said in client meetings, I know you have as well, where the client is really looking at us going, you're my last hope. They really are hopeless. They're like, if this doesn't work, I don't know what I'm going to do. And that can be anywhere from I'm going to be homeless to I'm going to maybe hurt myself. Or, I mean, you have these real conversations. And then they get that unfavorable and sort of all that hits home. One of the things I think it's helpful, though, to help lawyers, help clients understand is your frustration is understood, but your frustration in the decision is often with the way the judge interpreted the facts or the way a vocational expert said you could work. So can you talk a little bit about sort of what common client objections to the decision are and why they may or may not matter?
Sure. So one that I hear a lot is a client says, well, the vocational expert at the hearing said that I couldn't work. And oftentimes you go back and you listen to the hearing transcript. And really what happened was the judge asked 3 questions that were not work preclusive and had jobs. And then the very last question was about time off task or too many absences. And the VE says, well, that's work preclusive. And that's what the client latches onto and then is very disappointed when they get the decision. And they say, well, that's not what the vocational expert said.
Yeah. And what the vocational expert said was, under hypothetical 1, there are jobs, and under hypothetical 2, there are jobs, and under hypothetical 3, there's no jobs. And what actually happened is when the judge went back and looked and made their own assessment of the facts, they looked at it and said, well, I think hypothetical 1 is most consistent with the job. And that might be they're limited to light work, which means there's limitations on how much they can sit and stand and lift and carry. And, they need to limit their interaction with the public or whatever, and they come up with a job. So I think that's a big thing. The other thing I think we hear a lot is the judge said I could do something, but I can't do that.
Yes.
So how does that sort of play out? How do you deal with that? Because I know that's a common objection to the decision.
So that objection, I am looking to see if it's documented that you cannot do that. So if the judge is saying you can do something and all of the evidence in the record shows that you can't do it, well, we might have a basis for appeal.
Yeah.
But if there's no evidence that you can't do the thing the judge says you can do, then that's a tough thing to appeal on. Another objection that I hear a lot from clients is, well, the VA found me disabled, or workers' comp found me disabled, or my long-term disability carrier found me disabled. Why didn't the judge find me disabled? And so kind of explaining that, just because a different but related system has found the client disabled doesn't necessarily mean that the judge has to follow that.
Yeah, I mean, there's certainly cases where judges don't evaluate countervailing evidence. They don't look. They misrepresent the evidence.
Oh, absolutely.
They cherry pick the evidence. They just mischaracterize the evidence. I remember we had one case, and the judge, I remember this because we were going through the decision, and I think the judge said, well, the client at the consultative examination, which is where the Social Security Administration sends you to one of their doctors to evaluate, said the client was able to walk, and then the reality is like they walked, and at the end they fell down and had to grab the table and had to be helped up. And so the judge said, well, they were able to walk at the consultative
Yeah.
exam, but the reality was they did walk until they fell down and had to be helped to get back up. And so obviously we appealed that and we won that case on appeal. But I think, a lot of times though, the reality is what the evidence shows is maybe the person could or couldn't do certain levels of activity. The judge just didn't find them fully credible and believed that they could. But that's not really, by and large, what we're doing in a federal appeal and evaluating a case for federal appeal. What we're doing is looking far more closely at the judge is required to evaluate the evidence a certain way. Did they actually follow the rules and analyze the evidence according to the statute or the CFR, whatever they're supposed to do?
Right.
Yeah. So let's step back a minute and talk about how you help them make that decision. So there's sort of a couple of ways this can go. You could look at the facts and determine that there's legal error and that we should appeal. But what are some other results? I mean, what happens when you look at it and say, well, I don't really think there's much here? Like, how do those conversations work?
Those are much tougher conversations. And one sort of the elephant in the room we haven't talked about yet is the appeals council.
Right.
And
yeah, sure.
To even get to federal court, we have to go through the appeals council, which sometimes takes 2 months and sometimes takes a year and a half.
Right.
And so there's a certain element of unknown with appealing. So sometimes if I'm not seeing a lot in the decision, and maybe the client is going to change age categories in 8 months, and the RFC that the judge wrote would be disabling under that new age category, then maybe refiling is the better option. So one thing that I'm looking for is, are there things within this decision we can work with in 6 to 12 months with a different age category? Sometimes that's not the case, and the client's not going to change age categories, and we just have to say, can we file a new application? Is that an option?
Sure.
I'm not saying I don't believe you, but do we need to try going back to work just to prove that you can't?
Sure.
And so those are much tougher conversations.
So I think this sort of gets back to another issue. I know in our last episode where I was with Ari Stieber Hughes, we talked about, we touched on this concept a little bit of the difference between just sort of being their attorney and being a counselor. And I think in this space, when you get to an unfavorable decision, I think it's really important to be able to say, hey, there are multiple options here. And even though we may have a legal error that we could take to federal court, I mean, what's that timeline possibly look like? You got appeals counsel, which is the space between an unfavorable decision and actually filing for federal court. And then you're another year in federal court probably?
Right. So clients should be planning for about a year at the appeals council, about a year at federal court. And that's just to get back to the remand hearing.
Right. If we win.
If we win.
Yeah. So I think it's important that when people have an unfavorable decision, one, you need to understand it's not necessarily the end of the road. There's not a lot of them, but there are attorneys like you who specialize in sort of working through the federal court process and appeals. But really your attorney should be working through with you saying, well, what does it make sense? So maybe you should return to work. Maybe you need better medical care. Maybe you need to reapply. Maybe, like I said, you need to return to work and really try and see if that works. Or maybe you just need to reapply because there's a change in the rules coming that's going to help you. So let's jump to the end, sort of the federal court process. So we got a client, judge deny them all, gave them an unfavorable decision. We jumped through the appeals council hurdle. We got to federal court. We went through and we fought with OGC and they agreed that we were right, or they didn't, and the magistrate or the federal court judge agreed we were right. Now that case comes back. What happens then? How does that process work for the client once we win their federal appeal?
Yeah, that's a great point. So one thing that's a lot different in federal court is the file is not being updated while we're in federal court. So the whole rest of the life of the Social Security case, new medical records are going in. And then there's this pause at federal court where no records are received because we're just looking at what the judge had in front of him or her. So once we get that remand and we're going back for the remand hearing, then we're updating the file again. So we're talking to the client about, well, what changed since the last hearing? We're getting those updated records in. Sometimes that remand hearing is in front of the same judge, and a lot of clients are sort of uncomfortable with that because they're saying, this person denied me 2 years ago now. Why do I have to go in front of them again? But I always try to encourage clients that even if you do have the same judge the second go round, we do have a lot of success at the remand hearings.
Right.
And sometimes you don't end up in front of the same judge. Sometimes you get a new set of eyes looking at your file, and that's what needed to happen for us to win.
Yeah, and one of the things is there's very little. I come from a litigation background many, many years ago before the disability process, where we did domestic, we did criminal, and it's all about judge shopping and getting your case in front of the right judge. And there's very little of that in the disability process. But in remand hearings, oftentimes people have decided to go with a judge. Their case got outsourced. So say it was a Greensboro case, but their case got shipped off to Tallahassee or wherever, and they had a judge from Florida. Well, now they have the ability to come back and say, well, I want an in-person hearing now, and they have to give them an in-person hearing. So now we're necessarily not going to have a judge from Tallahassee. We're going to have a judge from Greensboro. So there's quite a bit of decision-making that goes into sort of even those sorts of processes when you're working through a case that gets remanded.
That's true.
Yeah. So when can you reapply if you've gone to federal court? Like, can you let's just go through the process. So you have an unfavorable decision. There's an interim appeal to what's called the Appeals Council, which is a appellate agency that just reviews disability decisions, still under the executive branch of government. And then you go to federal court, which we're going to hop over now. We're going to go to the judicial branch of government. I forgot my civics there for a minute. Can you reapply during that process for a new claim?
So that's the other thing that when I'm reviewing an unfavorable decision that I'm thinking about is, while the case is sitting at the Appeals Council, we cannot reapply. And so sometimes I'll be talking to a client who just something really terrible happened between the unfavorable or maybe the hearing and when I'm talking to them, maybe extreme example, there was a car accident and they're much worse off now. Well, in that situation, it may be better to file a new claim because the Appeals Council is only going to be looking at the hearing back. So they're not going to necessarily be considering a huge change in circumstances. And we can't file that new claim while we're sitting at the Appeals Council. But once we hop over into federal court, that is sort of the administrative level of the claim has closed, and we can file a new claim then.
Yeah, so it's not uncommon for someone to lose their case. We take it to the Appeals Council, then we go to federal court, and while they're in federal court, we go start a separate claim.
That's right.
And then practically what happens is, if you're usually, not always, but usually if we win the federal case and it gets remanded, then they take those claims and they consolidate them, and you end up with a hearing sort of on all the claims in that remand hearing.
That's right. The other thing that can happen is sometimes we win on the new claim while the federal court old claim is pending. And so then we end up doing an interesting hearing that's sort of like a closed period of the time before the new claim was paid.
Yeah. And so, and then you end up really just looking at a very limited set of facts, but you already have gotten your benefits approved. And a lot of times we do remand hearings with people who are already in pay status, they're already being paid.
That's right.
Okay. So why do you think because I personally believe the federal court system is not used enough. I think people, especially who represent themselves, rarely sort of come into this process. There are lots of attorneys who, for lack of a better word, are emotional about their unfavorable decisions. They either like the client, or maybe the client's difficult, or they like the judge, or maybe the judge is difficult. And they sort of look at the case, I would say emotionally. I mean, not in a sentimental way, but they're letting their emotion dictate whether someone should appeal or not. And as a result, a lot of people don't appeal their unfavorable decisions either to the Appeals Council or to federal court. I think you would agree with me. That's a huge mistake.
Oh, absolutely.
Yeah. So Talk a little bit about the process and why having federal court appellate practice, why having that work is so important to sort of the system, but to clients as a whole.
For sure. So I think one of the big issues is if we don't appeal, then that unfavorable becomes official. And
Right.
I tell clients all the time, you are officially not disabled in the eyes of Social Security. And so even on that new claim, you're going to have to differentiate your case starting with that unfavorable decision.
Right.
But if we win in federal court, what we're winning is a de novo hearing. And so that unfavorable is no longer binding, and the whole time period is at play. So it's not just about saving the back pay, which is huge, of course.
Right.
But there's also this, you're not having to prove why you changed since the last unfavorable if it's been overturned.
Right. I also think that there has to be a check on judges.
Oh, absolutely.
Yeah.
Absolutely.
So how does that process work to serve as a check on, judge denies them all?
That's right. So the agency does have some internal quality review metrics. So it always makes me a little bit happy when we can get judge denies them all overturned.
Right.
I just think, well, that's another mark, another decision that didn't stand. And big picture, the Social Security disability, the rules themselves are written in such a way that when you're reading them, they appear to be very pro-claimant.
Right.
But they are not enforced that way. In practice, there's lots of ways that the agency takes a very pro-claimant seeming system and spins it against our clients. And so
Right.
I think federal court is a way to sort of take a step back outside of the agency and say, no, this is a pro-claimant system.
Right. And there has to be accountability to the judges, just like in any judicial. I mean, the reason we have appellate courts is to bring a broader sense of hopefully fairness and justice to the system. And I think when you're looking at disability cases, there's so much at stake for our clients to not have that check on tremendous amount of power and authority that those judges have. Just allows them to do whatever they want to do, and allows the agency, which unfortunately doesn't appear to be neutral, even though it's a non-adversarial process, doesn't feel neutral at least. So with the federal court system, what we're able to do is say, we're going to check this, and we're going to ensure that people have fair hearings. And I know in sort of the appellate bar with the other appellate attorneys, most of them take great pride in the fact that what we're doing in these appeals is preserving the integrity of the system, which has to be preserved for people to have confidence to use it.
Absolutely.
Yeah, very good. Well, Carrie, my wonderful producer, is flashing me signs that maybe we have once again passed our time. But Aaron, thanks so much for coming on the show. I appreciate talking about what some people may think to be a dry legal topic, but appeals are really important because everyone's not going to win their case. But everyone doesn't lose their case because they're not disabled. A lot of times people lose their case because their claim wasn't assessed fairly. And what the appeals process does is allow you to have the opportunity to ensure that you have a fair hearing, which ultimately at the end of the day is what most people rightfully deserve and what they want. So with that, that's a wrap. That's another episode of the Disability Expert Podcast. Please subscribe, leave your comments, tell your friends, and join us next time when we talk to one of the nation's top disability experts. Thanks a lot.